Hello friends, in this video we are going to discuss about the prosecution proceedings under GST in light of the recent instruction 4 by 2223 dated 1st September 22 issued by the CBIC. The scope of our discussion would be when can proceedings be initiated, what can be the basis of initiating the proceedings, the monetary limit, the compounding of offences, how can adjudication and criminal proceedings run together, procedure for sanction of prosecution proceedings and its withdrawal, and other important guidelines which have been published by this instruction. First, let us understand section 132. Section 132 covers two kinds of persons: a person who himself commits an offence, or a person who is the mastermind behind the offence. That means he causes someone to commit that offence and retains the benefit out of it, right? Now, there are four categories of offences which are covered under prosecution. A person who supplies any goods or services without issuance of invoice. Second, a person who issues the invoice without actual supply of goods or services. Third, person who avails the ITC without actually receiving the goods or services. Fourth, a person who intentionally collects taxes but does not pay it for 3 months, more than 3 months, to the government. So person who is regularly collecting but not paying it to the government by stating that this is the tax which I am collecting, but he is actually not depositing it with the government. Now, what can be the basis of prosecution? First of all, there has to be adequate evidence which has to be gathered by the authority which is doing the prosecution. This would be far more than the evidences which are normally required for adjudication. It requires an in-depth investigation of that person. What would be the decision factor for instituting this prosecution proceedings? First, nature and gravity of the offence. How grave is the offence? What is the quantum of tax evasion involved? And what are the evidences which are going against it, and what is the quality of those evidences? Based on this, if the officer feels that the offence is very grave and the amount is very large and the nature and quality of evidence is quite reliable, in that case they may initiate prosecution. Mind you, in case of any difference in opinion, or because of any technical matter, any technical issue which is there because of which I have not been able to file my returns, in these cases the prosecution cannot be initiated, right? The officer should ensure that the guilty mind, which is mens rea, should be established. Also, they should show that there was knowledge of offence in the person who is the accused, and they had fraudulently tried to evade taxes, right? Prosecution not against all directors, but only those involved in day-to-day operations. So only those directors which are involved in day-to-day operations would be covered here, and not all the directors. So it has to be proven that those directors had given their consent to this particular activity of evasion, or the director was negligent or intentionally avoided to pay taxes. In such cases only the prosecution can be against the directors of the company, right? Now, question is, can adjudication and criminal proceedings run together? So Radheshyam Kejriwal Supreme Court held that both the proceedings, adjudication and criminal proceedings, can be simultaneous and they are independent. So they are two separate proceedings altogether. They can run together. It does not matter that adjudication is pending, still the prosecution can be there. Now, even before adjudication, the complaint may be filed before the court by the authorities for sanctioning of prosecution. So please ensure that prosecution can only be finally decided by the courts, right? Any court would be able to decide it. For that, the complaint needs to be filed by the officer before the court. So that can also happen before the adjudication proceedings are complete. Any evidence which is available against the assessee is sufficient, which is for instituting prosecution. Where offender arrested under section 69, prosecution complaint may be before issuance of SCN. So if someone has already been arrested under section 69, so arrest is different from prosecution. Arrest means a person has been arrested to make sure that the evidences are not tampered by that person till the investigation is complete. Whereas prosecution is where the person has been held guilty, right? So if a person has been arrested, then still before the SCN also the prosecution complaint can be lodged against him. Decision in adjudication is not necessary before criminal prosecution. So adjudication decision may still be pending before criminal prosecution is instituted. Findings of adjudication authority not binding on proceedings of criminal prosecution. So if the adjudication authority determines something that is not final and it is not binding on the person, right? So whatever the criminal authorities, prosecution authorities decide, that would be completely separate from adjudication proceedings. That can be separate, right? Finding in adjudication will affect the proceedings of trial. Mind you, whatever adjudication authorities decide or whatever findings they have, they should communicate to the prosecution authorities. In that case, in the trial, those findings can be used for or against the accused. If exoneration on technical ground and not on merit, prosecution may still continue. So let's say I have been exonerated because the officer did not give DIN number on the show cause notice. That means I have been released from the proceedings. The proceedings have not carried on. Because of any technical reason, the matter has been dismissed. Still, it does not matter, the prosecution may still continue. Where allegation is not sustainable and the person is held innocent. So finally, after the findings, the person is held innocent in adjudication proceedings. In such cases, criminal proceedings cannot continue because the person has been found to be innocent here. Now, normally punishment for the offences is where the amount is more than 1 crore but up to 2 crores is 1 year with fine, more than 2 crores but up to 5 crores 3 years with fine, more than 5 crores 5 years with fine, right? For subsequent offence, it would be 5 years along with fine. In any case, the imprisonment time period should not be less than 6 months. So whatever we said was the maximum time period. Also, for less than 500 lakhs, the offences would be non-cognizable and bailable. So bail can be obtained from the department itself, departmental authorities itself, the assistant commissioner, deputy commissioner, and the offences would be non-cognizable. But more than 500 lakhs, it would be non-bailable. So bail can be only obtained from the court, right? Also, prosecution cannot be instituted without the sanction of the commissioner. So minimum principal commissioner or the commissioner needs to provide their sanction. Interestingly, in the instructions, the limit which has been mentioned is only more than 500 lakhs. So it has been mentioned where that tax evasion is more than 500 lakhs, then only this would be applicable, right? Exceptions are two. One, there is an habitual evader of tax. So someone who is regularly evading taxes, who is an habitual evader, who has been involved in 2 or more cases in the last 2 years, and the amount of evasion is more than 5 crores in aggregate. So person who has been regularly offending the law, in such cases the limit of 500 lakhs would not apply for that offence. So earlier, if he had been already accused, or a person who is part of the arrest case under section 69. So person who has been arrested under section 69, for them also 500 lakhs limit would not apply. Now, compounding of offences. So compounding of offences means where I pay the amount and the proceedings stand abated. The penalty prosecution, the proceedings fully stand abated under the GST law. So what do I need to pay? Tax, interest, penalty, and 50 to 150% as may be determined by the authorities. The commissioner should be giving us an option that if I make the relevant payment, the offence stands abated, the proceedings stand abated. Mind you, if the proceedings are under any other law also, CRPC, Indian Penal Code, any law, if the person has made any offence under any of these laws for which the proceedings are also pending, in such cases that proceedings cannot be abated by compounding under GST. So compounding only abates GST, not any other law. Now, what is the procedure for sanction? Normally, the person who is the additional commissioner or joint commissioner should ensure that they have all the evidence and witnesses which are ready to state that there is a prosecution which is required. Based on those evidences and witnesses, they should file a proposal for prosecution before the commissioner within 50 days of arrest. So if the person has been arrested, within 50 days of arrest, they should be filing a proposal. Thereafter, the commissioner should be sanctioning the proposal if he feels fit, and the prosecution complaint should be filed within 60 days of arrest. Right? If the arrest has been made and the bail is not granted within 60 days maximum, the complaint should be filed before the court. So ideally, the authority, which is the sanctioning authority, should be filing the complaint before the court for final prosecution proceedings. Where arrest has been made and bail has been granted, still it needs to be filed within a definite time frame. Now, let us say arrest has not been made. The adjudication is still pending. In such cases, within 60 days of sanction, once the authorities sanction that the person should have prosecution initiated against them, even though they have not been arrested, this should be initiated within 60 days of sanction. Also, file appeal before the higher court. So if, let's say, the higher court gives a verdict in favor of the assessee, the department has been instructed to file an appeal before the higher forum. Let's say single bench had given a judgment, so they can file before the division bench. If the court has given a lenient view in favor of the assessee, either reducing the punishment or allowing him to go free. Now, normally filing of prosecution, when can it be done? If the arrest is not made. Before adjudication proceedings, if the prosecution is already sanctioned by the commissioner, in that case, they should inform the adjudicating authority so that the adjudicating authority does not get into the issues regarding prosecution, so that they don't have to examine the prosecution again. If the prosecution has been filed after adjudication and the view was formed by the adjudicating authority that prosecution is required, so adjudication is already on, adjudicating authority feels that prosecution is required. So at the time of passing the order, they should make a note that this case is fit for prosecution. Let us say the officer at the time of adjudication is not able to determine. In that case, the branch of adjudication, so entire branch, which is the commissionerate of adjudication, should forward in 15 days of passing of order that a view should be formed for prosecution. These views should be provided to the sanctioning authority. Who is the sanctioning authority? Commissioner. Commissioner thereafter would form a view based on what the adjudication authorities have stated. If the commissioner has already formed a view before adjudication, in that case, they should inform the adjudicating authorities. Right? Now, if the adjudication proceedings have concluded, in such cases, within 1 month of adjudication proceeding, a investigation report should be filed that this case is fit for prosecution, and this report should be signed by the deputy commissioner and assistant commissioner, and it should be endorsed by the additional commissioner and joint commissioner that this case is fit for prosecution, so that it can go before the sanctioning authority. That once the sanction is obtained, the case can be filed before the Honorable High Court. Withdrawal of prosecution, where prosecution is not filed and they want to withdraw the proceedings for prosecution. When new evidence comes to light, inform the sanctioning authority. So let us say the sanction is obtained, the commissioner has sanctioned, but this was not filed before the court. In such cases, if new evidence comes to light, in that case, the officer who investigates should inform the sanctioning authority, which is the commissioner. Now, withdrawal can only happen with the approval of the chief commissioner. So, commissioner should obtain recommendation from the chief commissioner. So, they should recommend to the chief commissioner, and thereafter it can be withdrawn. Where filed, it was already filed before the court. In such cases, prosecution was already filed. So, if it is found later on, upon adjudication, that there was no contravention of the law and the department is satisfied it is not going before any appellate authority, in that case, the commissioner should once again obtain approval from the principal chief commissioner, and approval would be only applicable once the court allows the withdrawal of prosecution. So before the court should give a option for withdrawal. Now, normally what are the guidelines which are applicable for prosecution? The officer filing complaint should take charge of documents to avoid delay in court. So normally before the court, the public prosecutor takes a lot of time because they don't have all the documents. So they are saying person who is filing all the documents should interact with the public prosecutor and regularly give documents to them. Also, even if the assessee has filed an appeal or a revision proceeding, still does not mean that the prosecution proceedings would be in abeyance. Prosecution will still continue. Appeal proceedings and revision proceedings will run separately and prosecution will run separately. So there should be a parallel file which would be there for appeal and prosecution separately. Also, the commissioner has the power that whoever is convicted, they can publish the names of those persons so that those persons are not dealt with in the market with anyone else in the future. So the commissioner can publish the names of those persons who are convicted. But mind you, person should be finally convicted here. Prosecution proceedings would be monitored by sanctioning authority, and inspection of this would be carried out by Director General of Performance Management, which is internally department would be regularly monitoring the prosecution proceedings very closely so that those proceedings are regularly abated within the time limit or regularly they are completed within the time limit. Right? With this, we come to the end of this video. I thank each one and every one of you for giving me a very patient hearing. If you like this video, please like our video and subscribe to our channel. Thank you so much.